MS Now senior legal reporter Lisa Rubin was in that hearing room. She joins me now from West Palm Beach, Florida. Ashley Parker is back with us, and also with me, MS Now legal analyst Catherine Christian. Lisa, first of all, talk about just the mood in that room and the driving message from survivors.
I think, Chris, the driving message from survivors was do not stop. You must find accountability. And accountability comes in a variety of forms. We heard from advocates who were saying, look, there are threads that still need to be pulled on in terms of potential criminal investigations that can be done. When the Department of Justice and the FBI said in July of 2025 that there was no more criminal investigation that could be done, the allies who testified today, including Lauren Hirsch from World Without Exploitation, that's false. But one of the things that we really heard today was sort of a new phase of the investigation in terms of a new survivor coming forward. Her name was Rosa. You just heard from her. And she said that Jeffrey Epstein began abusing her in 2009 when she was 19 and had just come to this country as a model from Uzbekistan. One of the things that's so important about Rosa's testimony is we know a lot about the women who were then underage girls who were abused by Epstein in Florida in the mid-2000s. But what Rosa says happened is that Epstein began to rape her when he was on house arrest and work release from his prison sentence in Florida for abusing those dozens and dozens of girls. That is abuse that continued. And Epstein continued to tell people while he was still alive, oh, that was a one-time thing. That just happened in Florida. I was arrested for solicitation of prostitution, but I'm an upstanding guy. Rosa and her testimony today flies in the face of the rehabilitation that Jeffrey Epstein enjoyed in New York and beyond after he was released from jail. Chris?
Catherine, I want to play a little bit more of what Rosa had to say because, again, this is the first time she has ever spoken publicly. Here it is.
I kept my identity protected as Jane Doe. I woke up one day with my name mentioned over 500 times. While the rich and powerful remained protected by reduction, my name was exposed to the world.
She's talking, obviously, about the files that were released and many of the women who said they did not want their identities revealed found their names in there. You can feel the pain in her voice. Is there any recourse that women like her have?
Well, unfortunately, the Epstein Act, had no penalty clause. So DOJ were able to redact things they didn't want the public to know, but clearly were, I'll say, reckless or sloppy in not redacting the personal identifying information of these victims, of these survivors. But there is no penalty clause in the Act, meaning if you violate the Act, this will happen. That's one of the loopholes in the Act. So it's horrible, but unfortunately the way this act was written, because it was written so fast, there is no mechanism for the survivors who did not want their identity released to, point the finger and say, I need, to get something, some justice because they released my name and they weren't supposed to.
Lisa did point out what is important about this is every time we hear from someone like her, there are new threads, right? And I also spoke earlier to Congressman Walkinshaw, who said, there may be a DOJ where there can be a real investigation here. But what do you see as the most likely recourse for these women who have been saying clearly, loudly, repeatedly, and at great personal cost that there are others out there who should be accountable?
Well, there, thankfully, is no statute of limitations for federal child sex trafficking. There is a statute of limitations for other crimes. So if people, and not all men, can be identified and you can prove beyond a reasonable doubt that they engaged in this behavior, they can be prosecuted, if not by this DOJ, another DOJ, meaning a different attorney general and different administration. For crimes that were not money laundering and other crimes, those cases are gone, meaning you can't prosecute them because the statute of limitations are gone. But for the adult women who were victimized when they were children, if they can identify, that's the key, you have to prove beyond a reasonable doubt, if they can identify the people who violated them, then there can be a prosecution.
Yeah, and one of the things that continues to strike me as I watch these, Lisa, is how supportive they are of each other. You see the support that Rosa was getting as she was giving her testimony.
Yeah, I mean, Chris, one of the things that struck me was that these are people who have been repeatedly failed by multiple institutions of government, federal government, state government, Congress, the Department of Justice. And so in the absence of government caring for them in the way that government should, they are caring for each other. I want to go back, though, to something that you and Catherine were discussing about sort of what the remedy is, because she's absolutely right. The Epstein Files Transparency Act has no provision to sort of sue the Department of Justice for the kinds of disclosures of victim information that Rosa and Danny Bensky were talking about earlier today. But this hearing has been unique because the Democrats have been talking about two particular pieces of legislation they want to advance. One is what they call a private right of action against the Department of Justice that would empower victims to sue the Department of Justice and recover money for the harm that has been done to them, that re-traumatization through the publication of their personal information. But the second is what Lois Frankel, a member of Congress who was the mayor of Palm Beach, refers to as the Courtney Wild Act. Courtney Wild is an Epstein victim who testified today. She was first abused by him when she was 14, but she brought a lawsuit against the government in 2008 because the Department of Justice never notified her, much less consulted with her and other survivors about that 2007 non-prosecution agreement that we refer to as the Sweetheart Deal. The Courtney Wild Act that Lois Frankel was talking about today would allow victims to have that right of notification even if the federal government hasn't already brought charges, so that if there is a plea deal with someone like a Jeffrey Epstein in the future and charges still haven't been brought, those victims will be notified and they will have meaningful consultation in whatever deal the government strikes. Chris?